na Oba Ghana ha ene the Attorney General and Minister of Justice the lawyer Godfred Yeboah Dame. Councillor Kwaba na pom to saying
Abachomado Namiado.
Yeah, Danyame ase. Me yiri say enra enkomo a the largest opposition party edi two dwa no wanya emu nsem no etie. Omo kiremu a mo aben yi ye nneoma bi aso mo tata NDC mpanyifo and people linked to the NDC into omo the petitioner Commonwealth Secretariat say the ekoso wo ye manyim na ni enyan. We are Attorney General of the Republic. O jene saying me pacho.
Well, pacho any Bia, it is totally baseless. And I think it's just an attempt for them to avoid justice. They are clearly seeking to run away from justice. So we say, being your Ganano, yes, Shamrasi. And Ufumra, and require say dealing with you. There is no one who is above the law. The law is no respecter of persons. And I think it is totally unjustified for any person to think that on account of being a member of the NDC or a DD member of the opposition party in Ghana, that person is immune from prosecution. No one is immune from prosecution in Ghana. Even former presidents can be prosecuted after 3 years. So there is really no immunity, properly so-called, from prosecution in Ghana, accorded to anybody by any law in Ghana. So, when these workers International Court, that's Omoko International Forum, they are petitioning Commonwealth Human Rights, Amnesty International, and all. I consider all as a ruse, an attempt to run away from justice. The courts of Ghana are supreme when it comes to enforcement of our laws. The Constitution has accorded sovereignty to the people of Ghana. Sovereignty resides in the people of Ghana. It doesn't reside in foreign people. It doesn't reside in international bodies, Commonwealth Human Rights, and Amnesty International, or whatever. And there's no way Ghana as a nation is going to consider our court subservient or subordinate to the supervision of any foreign entity. That's what will never happen. I mean, this is not the first time, as I said, NDC for say, pursue more accountability or more have a recourse to international forum. They do that all the time. Recently, they petitioned the international forum when they knew they had no basis when it came to the bonds that were issued by Honorable Ken Ofrata. Around that same time, Woyobe, when he was being pursued by my humble self in the courts of Ghana for accountability to the people of Ghana as regards the sum of 51 million Ghana cedis that he had wrongfully been paid by the NDC administration, purported to resort to the African Court of Human Rights. As Koshi said, I had to go all the way to Tanzania to defend the government of Ghana in the African Court of Human Rights. After a whole long hearing trial, the case of Uyumi was dismissed by the African Court. The allegations that he made, the Supreme Court of Ghana bias, the Supreme Court of Ghana no ultimate justice. The African Court debunked each and every allegation he made. And they said that no, Ghana government, we have every right to ensure the enforcement of our laws through the Supreme Court of Ghana. And insofar as a matter bordered on an interpretation of the Ghanaian Constitution, the Supreme Court of Ghana has a sole and exclusive jurisdiction. It cannot be shared with an international body or international forum at all. What do you mean? Or review by international, the African Human Rights Court. That same court unanimously dismissed the action. The rulings are there. So I think that I consider it as very hypocritical on the part of the NDC. Hypocritical because, say, only 1 or 2 rulings in their favor. They hear the rulings. They celebrate it. Remember, openly, challenge the certain decisions that have been made by the presiding judge over his matter. Justice Onyenuga.
Yes.
Of course, the Supreme Court. The Supreme Court initially ruled in his favor, a narrow 3-2. And they really ruling, they have cleared Justice Onyenuga of the matter. We're hailing it. And I also resorted to the same Supreme Court. I resorted to a process that has been guaranteed under the Constitution of Ghana, which is invoking the review jurisdiction of the Supreme Court. And the Supreme Court set aside the ruling by the ordinary panel after arguments had been convincingly made by me. And so I think that all these attempts by the NDC to undermine the integrity of our judicial institutions and institutions of good governance in the country should not be countenanced at all. I consider them as unnecessary distraction. I think that they are a palpable and a very poor attempt at avoiding justice in the courts of Ghana. Everybody is accountable under the laws of Ghana. Everybody is accountable for his action some way or the other. And if you look at all the allegations, each and every one of them, without basis, the case of Ato Forces that they were commenting on yesterday, the facts are so glaring. It's an agreement that involved a foreign entity, Big C Gulf Trading Limited,
yes,
in Dubai. That agreement did not go through Parliament. The fact that they had early on purported to receive some form of parliamentary approval for the transaction is immaterial, because that approval that they had was not one that involved Big C. It involved a financial agreement which they set aside. They put aside that financial agreement which had been approved by Parliament, and then resorted to their own mechanism to undertake the transaction. Indeed, that in itself would not be criminal. It becomes criminal when the object of the transaction is not attained. The object of the transaction was to import ambulances for the people of Ghana. So the question is whether ambulances were in truth and in fact ordered or imported by the administration. The ambulances came from November, December 2014 up to February 2015, as the time they were leaving power in 2017. The question is, did they have any ambulances? Had they received any ambulances whatsoever? They have not utilized any ambulances or any vehicle that has been purportedly imported to the country as ambulances. So I think that the people of Ghana should not listen to them. And indeed, I am not surprised that they've resorted to all these shenanigans. I'm not surprised because it is their stock in trade. Whenever they think that they have their backs against the wall, and whenever they think they're in a tight corner, then they resort to all these machinations.
Yeah, but Honorable, for example, Enra Omu make the point about Omo national chairman, for example, say Oshe Nasema Ewo court now. Even the prosecution witness, witness statement on my, he claims onye aware about the details of that statement, any the signature was onim baby efi, and they believe based on a that admission by the prosecution witness, the case should have been moot. I was saying a discontinued case, but because I'm more persecuted national chairman inti and I'm Sujana court.
What kind of spurious reasoning is this? The deception of the NDC. They will usually pick one portion of a witness statement and then go on radio and start talking about it. And for me, that is with contempt. You cannot pick one portion of a witness statement and start making allegations and inferences on radio. The proper thing is for the whole of the prosecution's case to be put before a trial judge and for the trial judge to make a determination. You cannot, on account of one statement or one portion or even one line of a statement filed in court, which is subject to cross-examination, go and scream on radio that you are innocent. I think that's even contemptuous for the court. So what they have to do, as I indicated, is for them to focus their energies in building a proper and credible defense to any charge that is leveled against them. I mean, this is not the first time that I'm conducting a criminal trial. I conducted a criminal trial on behalf of accused persons when I was in private law practice. I conducted criminal trials on behalf of accused persons standing trial for the offenses of causing financial loss and alleged breaches of procurement laws. the case of Oseji, the very first case that was prosecuted by the NDC. I mean, it's an example. I conducted the defense of the accused persons in the matter. After a full trial by the NDC, the attorney general had been appointed by the NDC at that time, in which they called 70 witnesses. All the charges were dismissed. So really, I think that they should focus their energies properly. And that, for me, is a very sad testament to their attitude. They have the predilection to engage in all these distractions, and that even prevents them from conducting an able defense to cases filed against them in court. You would never find me when I'm counsel for an accused person or counsel for a defendant against the state go on radio and make comments on the matter. I would rather. That is why, with all respect, I was having a lot of success in my private practice, and that is why I was a danger. In all humility, I've had a lot of success. Because I will not. In fact, this is actually the first time I've had to respond to them. They made such an allegation. They actually came out with a written statement in response to the ruling of the Supreme Court on review in the opening matter. I ignored it. They made all kinds of aspersions that the judgment was concocted and all that. I ignored them. I just don't understand why they have that tendency.
Honorable, into the awoka and with the greatest of respect, say, Omachi ne doors my Yeboah, because when chief be brainer 8 you almost say break a castle down, Emma. Aha. And the Yanami Busane say, in the case of Ufuswam Pofono, are you still insisting, as what Attorney General said, state no still a credible case against him?
Well, I'm sorry for reminding me that when she for the commander for Xposed for where I stayed and the assumes read before Papa Yes. But what I'm saying is I'm sorry, Mr. Both of you. And Patrick say case no cause for court. We have prosecutors, seasoned prosecutors from the office at Israel, who have mounted charges against the gentleman you mentioned, the chairman of the NDC. He should direct his energies at defending himself in court. And he has also very competent lawyers. So I don't understand why they should go on radio and rather be making these suggestions. The court will determine. Apart from that, all the imputations and suggestions they've made in relation to the police trial, forcing and all, are totally misplaced. And I'm saying that the prosecution is being mounted on account of thorough investigations that have been conducted. Each and every case we have filed against the NDC is all on the strength of painstaking investigations that we have conducted. And I have to place on record that these allegations are not going to deter me at all. It doesn't mean that because any people have started screaming on radio that they are being persecuted, I'm going to stop prosecuting. I will continue to prosecute. If any docket is worthy of prosecution and it involves an NDC official, that docket will be prosecuted. All cases involving financial loss committed by the NDC elements, insofar as they've been thoroughly and painstakingly investigated, insofar as we are satisfied that the charges that ought to be brought against the NDC people, the cases will go to court. So all these distractions will not determine at all.
How about
and I also
cases,
have to say that it is the courts of Ghana which will determine the guilt or otherwise of an accused person. It is not an international body, Amnesty International, they themselves will decline any consideration of such a petition. So in your Ghana, Amnesty International, Commonwealth for Ombeamo, and Kwesifi, the tenor of me, and in respect to the Ken Bond and the Woyomi Africa Court, and Kwesifi.
Honorable, how about cases involving NPP officials and so?
Yes, the same thing. Same thing applies. Indeed, when in this country, when ABAJ was referred to a public prosecutor, ABAJ was a member of the Public Procurement Board, in fact, the Chief Executive of the Public Procurement Authority. When I was Deputy Attorney General, was on the Public Procurement Board. I served on it with him. We looked each other in the face all the time. At the time his matter came, I was still a member of the governing board. That did not prevent the president from referring that his conduct should be investigated by public procurement, by the public prosecutor. So, and it's also important to note It be a J case in Bayern. And then this follow me immediately. They be cited as an example of corruption in the MPP administration. Now, there's evidence of corruption against you. Now say you're prosecuting them. Say, hey, foul play. And America say hypocrisy on. Therein lies a hypocrisy on their part. Because you have these glaring pieces of evidence that show malfeasance on their part, and you are prosecuting them, and you don't want to be held accountable. What kind of reason is that?
One other allegation against the Attorney General's department, and it's in the case of Opuni trial, no.
So just to emphasize, it is just, I mean, once any docket at all,
yes,
where the prosecution has come to my attention, which has been investigated by the CID people, whether it involves NDC, MPP, PCP, whatever, they will be investigated. They'll be prosecuted.
They will be prosecuted.
As simple as that.
Oh,
I mean,
they made the point, say, Opuni trial, no, discovery phase, now, as some evidence be a prosecution, the person rely on, no, you are denying the defense, no, copies of those pieces of evidence. What is our seminar?
Well, sir, case came up even in the Supreme Court. I argued against it. The Supreme Court upheld my arguments on review. So, the court ruling, Supreme Court ruling a final. And I do not think that rule of law can be promoted in Ghana when people seek to advocate a position which undermines the integrity of final decisions of the Court of Ghana. I mean, so their conduct is very deplorable. Their conduct is very, very dishonest and deplorable and ought not to be tolerated.